Welcome to the Smithfield Planning Board meeting for February 27th, 2025. Before we begin, I'm going to have the emergency evacuation and health notification. In case of an emergency, there are two main exits out of the chambers. The first one is to the left side of the stage, up the stairs, through the doorway, and down the stairway out the back of the town hall. The second is out of the back of the chambers, the exit doorway, to the stairway, out the front of the town hall. The men's facilities are through the back of the chambers, past the stairway, around the corner on the right. The ladies' facilities are through the back door of the chamber, straight up the stairs, and on the left. Please do not use the elevator in emergencies. Before we begin, it's my understanding that we may or may not have members of the public here that have an interest in the matter referred to as the collection. That matter is not on today's agenda. Everyone is welcome to be here, but I wanted to make sure everyone knew it was not on the agenda for today. With that being said, we're going to have a review of the minutes for January 16th, 2025. Does anybody have any comments, corrections, and or additions? With none being said, we have a motion.
Motion to approve.
Second.
All in favor? Aye. All not in favor? The ayes have it. Noted. Turning to regular business, regular agenda, old business. The attorney, she's here. Smithfield Village, ID 16008, request for an extension of the final plan of approval.
Good evening. I'm here for my annual visit. It's nice to see everybody. I didn't know you are all having a sale tonight, so I will be brief. I have, for the first time in a couple years, I have views in that we have a purchase of this property and we have a plan. We've been working with the town. We have a draft ordinance amendment to submit, which we plan on submitting next week. So I'll be back in front of you potentially next month for a review of some zoning amendments related to this property. So this is for an extension to preserve the approval that's already on site. You will see in the new proposal some retaining of that residential component and a change to the commercial component. We expect that staff, as well as this board, may have comments on the zoning ordinance amendment, but what will hopefully be in front of you, subject to this extension, is a really great project. So, and you will see the details of it. Again, we're going to introduce it, so as long as the council refers it, either I'll be back, fingers crossed, next month or the month after with detail. But we are finally ready to go for a few members on this board. This site's been an annuity for all of us, and I'm looking forward to moving this project forward. I do have my clients here. We don't have the details yet, but we're looking forward to presenting that before you.
When you were here last time, we had a discussion about good cause and what good cause was.
Absolutely.
And it appears that a good cause that's used in the standard for reviewing our particular board's decision to grant or not grant extension is similar to, I know you're very familiar with Rule 55 of the Superior Court Rules of Civil Procedure, where there are no intervening equities, any doubt about the existence of good cause generally should be resolved in the favor of the party seeking to establish good cause. So it's an easier burden for a party, and there was litigation in Superior Court where this particular standard was adopted regarding zoning boards' reviews of matters and planning boards as well. Is that the standard that you're relying on?
Yes, it is, Mr. Chair. And I think I'll echo what's been happening in the last couple years with this site is that unfortunately, fortunately, we got final plan approval. Unfortunately, that was February 2020. And all the components to the site will became feasible with market change. Since that time, the owner, Stop and Shop, the grocery store was never going here, nor is it in the future plans, but was seeking a partner to develop this. We've been readily apparent to this board that may include the market change to all residential. We were talking to some of them. That has changed back for this project. So you're not going to be looking at an increase in units than is already allowed at the site, which I think is good for the town, since I think you have some pretty significant development in front of you at the moment. So, but yes, I would agree, Mr. Chair.
Any questions, any members of the board?
Yes, what is this Rule 55?
Well, Rule 50, it's a Superior Court rule of civil procedure, believe it or not. And the standard that the case law from our court system in determining what good cause is, they establish through a number of cases. You generally see it very often in litigation, whether a party has good cause to vacate a decision. It appears that same good cause has been adopted when reviewing whether a planning board grants good cause or not. The same exact standard applies. And that's the point, because we had a discussion last year, I believe, what was good cause. And here is,
Good cause meaning progress?
good cause is almost, unfortunately or unfortunately, depending on how you look at it, is for the reason for the request for the extension.
I see,
And-
okay.
And it's a easier burden to establish good cause for an applicant based upon that particular rule and standard.
To build on that, there's a different standard, a heightened standard, as the chair knows.
The extension's different. It's an easier burden for an applicant to overcome.
But it sounds like this is going to be a whole new proposal with amendments to our zoning.
A
And
portion of it, and I think,
Why
some
do you-
updates that are needed.
why is the extension of the old project needed if a new project is coming before us?
So the new, the statutory amendments allow this project to get modified. It needs a public hearing, everything like that, but we can keep this project in place, seeking a formal amendment, which is what we would do. I think you're talking about a timing perspective for this project to
What
get off the
happens
ground.
if the board doesn't grant the extension?
Then you likely don't see this project.
Don't see the old project, we see the new project.
You don't see either project.
Why is that?
Because this is, without getting into the details, these users for this site, as you know, Mr. Moen, this took 17 years to get permitted the first time. These are not uses that can wait for a potential another market change in this.
I believe it can be qualified as like a major change to the
Yes.
final plan.
Yep.
The final.
Which allows for public input and a full hearing in front of this board. There will be amended state permits as part of this as well.
Any other questions of board members regarding the request for extension? Okay, discussion?
In my opinion, I would say that we.
Microphone.
Because I would say that we let it go one more time and just, hope for the best, because what else are we gonna do? We're gonna keep starting it. That's a mess over there. We're gonna keep building faith and trying to get it done somehow. And I kind of believe they're not bluffing about going out financially. I think their feet has been put to the fire.
Mr. Chairman, I make a motion that we grant the extension.
Did you have a comment?
No,
Okay, second.
Just one question, one comment. When did you say you'd be back before us with this amended?
I'm going to submit the zoning ordinance change next week. So that's contingent on, I believe, and I'll defer to your solicitor, but I believe the council has to introduce it, formally refer to this board. So
Yeah, okay. Couple of months.
I would imagine we're back in front of you at the latest in April.
Okay, thank you.
And that is different than the amendment to the full public hearing, the technical details. First, you will get to hear basically a pre-app and the recommendation to the council. And then after, fingers crossed, a passage from the town council, it will be back for the technical details.
So we had a motion, we had a second. All in favor? Aye. All not in favor? The ayes have it.
Thank you very much.
Moving to Amelia's Way, 260 Old County Road, ID 2405, public hearing.
God bless you.
Mr. Chairman, for the record, my name's Timothy Kane. I'm an attorney licensed to practice law in the state of Rhode Island. And I have an office at 627 Putnam Pike in Greenville. I represent the applicants and owners with regard to this proposal. As you know, this is not a comprehensive permit. I think there's a lot of people here that have problems with comprehensive permits. This is not that. This is a 3-lot subdivision on a total of 6.5 acres, 6.47 acres. It would be served by a private road. There would be no maintenance to the town. And we were before you last November. We did a site visit earlier in the fall, so I think most of you are thoroughly familiar with the property and the project. And you sent it out for peer engineering review with the town's consulting firm. And it has been a very detailed, laborious engineering review. And you've gotten lots of comments from your engineers, and our engineers have responded to those comments and made several changes to the plan. And arguably, the peer review process produces a better plan, and it protects the town's interests. So I would like to have Mr. Casali, the professional engineer for this project, summarize the peer review process and highlight the changes that were made to the plan for you. And your town planner also has highlighted those in your staff report. And I would remind you that he has made a favorable recommendation for approval, so.
So it's my understanding that there was peer review with comments, and Mr. Casali, you have not, or addressed all of the comments as of yet?
Yeah, we've addressed the comments. We also had DEM comments that changed the plans. Peer review came back from the third iteration. We resubmitted, we haven't heard back from them.
Okay, so you have had the opportunity to respond to the peer review in total?
That's correct.
Okay.
So, Mr. Casali, could you summarize the changes that were made to the plan as a result of peer review comments?
Yeah, I can. Sure. Joseph Casali. If I may, Mr. Chairman, I can get into some of the drainage. So first of all, good evening, just for the record, my name is Joe Casali, I'm a registered professional engineer. Offices at 300 Post Road in Warwick.
Swear in? Hang on one second. We want to swear you in. You swear to tell the truth, the whole truth, nothing but the truth?
I do.
Better.
So, Mr. Chairman, you know where this property is. We took a detailed site walk not too long ago. You see Route 295, Farnham, Old County Road, and that's the subject parcel, specifically Assessors Plat 43, Lot 75. As Attorney Kane said, it's about 6.5 acres in the R medium zone. When you look closer at it, you have runoff from 295 going acting as a tributary to Georgiaville Pond, ultimately into an area subject to storm flowage that passes under that culvert in Old County Road. And you also have a stream defined by DEM that also contributes to that. What you've seen just come up, that's the freshwater wetland edges that exist around the stream and the tributary. You see the buffer zone that we're not allowed to work in. And then the new regulations, you see the DEM jurisdictional area. So anything that's going to be north of that line requires us to solicit a DEM permit, which we have filed for. So what the applicant's proposing, he's proposing a private roadway. It's about 430 feet in length, 20-foot paved, and a 30-foot wide right-of-way. And that's to service 3 house lots that would be in the subdivision. You can see all of them will be out of any DEM buffers, any DEM impact areas, but some of them will be in the jurisdictional area necessitating the need for a permit. So in terms of relief requested, there's a bunch of waivers, a couple of them procedural and a couple of them because of the private roadway. But most importantly, this waiver is required to reduce one of the lot sizes, specifically Lot 1. It's about 40,000 square feet is proposed, slightly less than an acre. As you know, in the medium district, 65,000 square feet if there's no public water or sewer, which we don't have. Also for the roadway width, respectfully requesting the right-of-way to be reduced from 50 feet to 30 feet, and then inside that a 20-foot road versus what is required by code, which is 30 feet on a private road, so 10 feet in width of roadway. Also, when we walk the site, you see how sharp the grade was. Not so much in the initial roadway, but when you get near that cul-de-sac, we're requesting that the slope of the roadway be increased from 8 to 10%, and also that that cul-de-sac be able to be sloped at 2% and not 1%, just to alleviate some of that change in grade. Curb radii reduction from 20 feet to 15 feet is also proposed. In terms of the fire truck access, you can see that's the 40-foot right-of-way, the 35-foot pavement radius. That's the largest fire truck that the town has, almost 43 feet, and you can see how it can make its turnaround within that geometry. In last 2 waiver requests, we do not yet have our DEM permit or our DOT permit. Any approval tonight, we would request contingent upon, but because we're at the preliminary plan approval, we're here requesting a waiver for the state permits to be handled at the final plan. In terms of drainage, you see that the whole site proceeds really north with that high point here at elevation 325. What we're proposing would be reductions to both the houses in the nearby area and also that culvert. And the way to do that is we have a series of drainage appurtenances that are going to collect that drainage and funnel it down into the state highway. And we have a series of drainage appurtenances to protect any of the adjacent abutters. So what we can see in terms of that drainage culvert, that, Mr. Chairman, will be part of our DOT application, to remove and replace that culvert so that it functions correctly. I think we all saw when we were out in the field, it was more of a conveyance issue because that corrugated metal pipe is crushed pretty good. That's some shots that we saw that day. You can see just how it just hasn't been maintained and how its structural integrity. But that's the science. Here's the math and the science behind all of it. In terms of the culvert, you can see reductions in the peak rates and also all of the volumes, which is why we expect our DEM permit. And the same thing with the state highway. We have reductions in peak rates, and we even have reductions in volumes until you get upwards of the 100-year storm event. That's the overall watershed when we're looking at this project and what it affects. It's actually pretty small. It only really encompasses a portion of the federal highway line and so forth. And that little diagram, that orange area is the area today that moves towards the adjacent houses and the culvert. So you can see the drainage design just by its conveyance of taking the water away from the backsides of those houses and out of that culvert area, that we can see that, empirically and emphatically, we're gonna have reductions. Septics for these lots, wells, individual wells, none of them will be within the radii of the septic. Water main, proposed hydrant location for fire protection. Domestic will service the houses through the wells. And one of the last waiver we're asking for, it's required that if you're within 2,500 feet of a public water line, that you would tie in and bring water up. It's not economically feasible to run an 8-inch main up there just for domestic service, when we have fire protection right outside the door. So again, just in terms of permitting, tonight, our preliminary plan with waivers, I know we've been continued from last month. Our wetlands permit is pending. A subdivision suitability from DEM is pending, as is our physical alteration permit. Soil erosion ultimately with the town, and final plan either back before this board or with the administrative officer. Mr. Chairman, I'd be happy to answer questions, you members of the board.
All right. Do we have any questions of Mr.? Huh? Does anyone have questions? Let's begin with
There you go.
that side of the room to avoid any of those issues.
Not right now. Finish the presentation.
Sure. Any questions?
Richard, you have to speak into the microphone. Before you can't hear you.
I'm sorry. No questions right now, but perhaps when the presentation is complete.
Sure.
I got a couple of questions before we.
Okay, Charlie?
My question is, the Crossman thing, do we have any paperwork on it so I can look? I got it on my phone, but it's all, why didn't, the whole report, I didn't get it in paper. So it's very hard to combat what he's saying without looking at my phone, and so I was just wondering why we weren't provided with the paperwork on that.
I think Mr. Phillips emailed us copies of it.
I don't have.
It probably came in after we got our packages delivered
Right.
for this week, so that's probably why it was emailed.
You should have Crossman's comments in paper form.
I only got it on my phone.
I think we got it in an email. It was a voluminous
Yeah, an email.
document.
Did you get one?
Mr. Chairman, are we talking about the stormwater review memorandum number 2 dated February 22nd?
I believe so,
That's
the
the
peer
ones,
review.
yes.
It's about
Peer
15.
review document.
That's correct.
15 pages.
Yes,
Yeah. Yeah, that was by email.
by email, and I think it was after
Charlie.
we received the package.
I know it's kind of late. Have you read it? Would you like?
No, I read it. Like I said, there's so many things in here that I don't know where to
Because
start.
there's still a lot of unanswered questions with this too.
So I don't see why we should even go any further without, this is the main thing this engineering thing, he hasn't responded to correctly, in my
What-
opinion.
Not that we know, because there were additional comments, plus there were unresolved comments
Unresolved.
by our peer review company.
The main thing is like the roadway, the waterway,
The-
the most important parts of this
drainage.
presentation has not been fixed.
Well,
He has no reason, there's no way, he hasn't shown any way, saying that he has any intentions of fixing it or going to do it.
let's hang on one second.
So I think we should stop it.
Mr. Casali, so we received the peer review from Crossman. You had responded to Crossman. Crossman indicated that a number of the issues had been resolved, but there were still some outstanding issues. Can you tell us how they were addressed?
Yeah, I mean, in terms of,
We'll start from page 1, Joe, if you'd like. I'd like to. Some of them are really concerning.
would you like to run the gamut?
Well, I don't know if we need to run the gamut. I think if
Oh.
if you have an issue with respect to an unresolved issue that's a concern, then let's do that, but let's don't reinvent the wheel if we don't have to.
Well, I think the wheel should be, in my opinion, the wheel should be addressed because some of these things that this company has addressed are very serious. And you didn't give a response to, and I'm wondering why you didn't give a response to some of, you responded to some of them, Joe, but
We
not all of them.
responded to everyone. Some of them weren't some of them, when the DEM changed the plan, some of the comments became moot. Regardless, we stipulate to any approval would have to be contingent upon ultimate peer review approval. We're not going anywhere any further in this project without, because you don't have a town engineer, Crossman substituting as your town engineer until we get ultimate approval from them, which respectfully I don't see as a major hurdle. This project can't proceed regardless.
So what you're telling us is you're in agreement to working with Crossman, the town's contractor who's peer reviewing, to make sure both in an agreement that all issues are resolved.
That's right. And so in terms of, we need to make sure that not only Crossman is happy, but a soil erosion meeting is approved, DEM is happy, as well as DOT. Yes, of course, we would stipulate to all of that.
Now, Charlie has a different question.
My point about this, something like that, like, you're gonna have to change on paperwork to show that they want the roadway widened, they want a culvert underneath it, the basins are not up to what they think. I mean, there's some major
Can you be
things.
specific, Charlie? I don't see anywhere where they want the roadway widened.
The view that says, that's what I'm saying. All right. I don't have a good decision. All right, proposed rear station. They want a pipe to go underneath the driveway. We'll start with that one.
Did you hear the question, Mr. Casale?
No, I'm sorry.
The drainage system on the front of the road,
Yes.
they say it's not adequate. It's going to flood. They also said that the pitch of the road is too high. They said the drains are long. The manhole covers, I mean, it's like I said, we want to start, everything on here that Crossman said that you could fix, you said you could fix, but others, you said that you didn't. Like this, like I said, if I had this, I could have circled on paperwork and talked about it. My point about this isn't like that, you know. You know that there's some things in here that should be addressed that you can't address, and I just haven't brought them up, and they're like, we'll continue, and I'll find them for you, okay? Give me a minute. So you can go on, Mr. Chairman. Okay.
Any other questions of Mr. Casale of the board before we continue with the presentation and or the public hearing?
I'll just give, Charlie's working on the same document, but and I know which ones he's referring to, but I'm going to let him handle it. But under the, let's see, there's no page number. Oh, yeah, here we go. Page 13 of 15, under new comments. So those are the ones that your engineering company
Oh, yeah, that's what.
has responded to most recently. But we haven't seen those responses to the new comments from our peer review company.
That's correct.
Acting as our engineer. So okay, so we haven't seen those.
We haven't seen those, and he says whatever we do is conditioned upon our Crossman signing off on being acceptable to them.
Yeah, okay, all right.
Why don't we see it first?
Which, that might be where we're going to go with this.
Yeah, I would postpone everything till we have every piece of paper that we need to look at before we make a decision.
And I think the board should see the final too, and approve the final.
Mr. Kane, would you like to address some of the concerns that were raised?
Well, as you know, We had an initial round of extensive comments from Crossman. We addressed all of them. We had Crossman's response to those. We addressed all of them. And now I guess we're waiting for Crossman's response. I'm going to go on a limb and say, if the public might want to speak, we would like the board's support. We would like everybody's support. I realize we might not get that, but I would suggest that it be continued. When are you meeting in March?
For when?
When's your meeting in March?
20th.
Okay, I won't be here. I'm taking 1 week vacation this year, but I can send somebody. And we will work on getting Crossman hopefully to respond to our comments in a timely manner, so we don't keep on this gerbil hamster wheel.
Just so we're clear, is my understanding that Crossman has responded? There was few unresolved issues, and we're waiting for Mr. Casali to respond. Is that correct? Okay.
There were new comments that have not been responded to by Casali.
Yeah,
You're here tonight
to address some, but,
to discuss those
Yeah.
that they think they can address of the new comments. I don't know if they're prepared to do that.
Mr. Chairman, just so that we're clear, this is a February 22nd memo? Okay.
yes.
Because I think the
Responded
thing,
quickly. It's not been a lag. We've been back and forth. It's only
yeah,
been
no, so, but we do have all the comments from February 17th. It's the February,
The
it's the February
22
22nd.
Crossman's comments.
Yes.
Where they went through,
Yep,
noting majority of the issues were resolved, but there were a handful that were not resolved.
Yep.
And I think Mr. Casali is going to be, either has verbally addressed them, but it hasn't got to pen yet for Crossman to give a formal response.
Great. I just-
That's my understanding
Clear
of the history of where we are.
there's a lot of memos, just want to make sure we're all
Yeah,
on the same.
and as I understand it, Mr. Kane is willing to continue the hearing to make, given Mr. Boyd's concerns in part, to make sure everything is addressed in paper so that we have a full record before us.
I think Mr. Moon's concerned also, and I'm not a mind reader, so maybe there's other people on the board that are concerned, and we've come a long way with this project, and I'd rather go another month and see if we can address everybody's concerns.
Thank you. The reason why there's quite a few people around that have a lot of concerns about it. There seems to be a lot of concerns between the engineers, the people who live there. I just don't have all the responses.
Yeah, I would respectfully submit, I think we've addressed the majority of the concerns, but if there's a few things lying out there that you'd like to see come to a conclusion, then I'm requesting that the matter be continued a month.
Attorney King, do you anticipate, Mr. Casale, do you anticipate DEM further commenting that can change this back and forth a little bit?
No, I don't know that we'll have a DEM permit by March 20th. I don't know, Dave, if we'll have a DEM permit by March 20th. It may come in by then. It should be close. I don't anticipate another round of DEM permits, no.
There's going to be a significant round of comments with DEM that's going to affect what you have to do that then affects Crossman again.
That's correct.
And Mr. Sillo, there's probably members of the public here today. Do we do public comment today, or given it, if the board votes to continue it, do we defer the public comment
We'll
till?
defer the public comment because there hasn't been much yet.
And
We haven't fully addressed their presentation.
And will there be separate notice, or is today's meeting considered notice?
Today is the notice along with the public advertising.
Okay. All right. So do we have a motion?
Just for the record, I want to impress upon everybody in here that we have done a ton of work addressing these concerns. I don't want anybody, including the people in the crowd, leaving with the impression it's just a process, it takes time, and we're going to cross the finish line hopefully next month. I mean, the work that goes into them is voluminous, as you know, and you're going to get it in paper, and you can wade your way through it.
If those concerns can be addressed and fixed with the culvert and the water problem, not, you know.
Yeah, the culvert, we're going to replace, so that's going to get fixed.
It does flood over there pretty badly.
Microphone.
Like I said, the concerns that they have, are the same other people, is the flooding over there.
And is the culvert being fixed under the? I haven't answered that.
For Mr. Boyd's question?
The culvert in question on Old County Road, that's the figure.
Hold on.
Let me just finish. I'm just trying to make sure, I'm trying to confirm. said you're fixing the culvert, is that under the road of Oak Island?
That's right, yes. Part of our DOT application will be for the applicant to fix that culvert. So he's gonna have to clean it out, replace the head wall, and fix the crushed corrugated metal pipe which was under the road.
I missed what the question was to the public.
Without public comment, is it okay for a question? Without public comment, is it okay for a question?
No,
No. That's what I thought.
I'd rather wait till the applicant has completely finished their presentation on these issues.
Yeah, and just for everybody to know, documents were exchanged between the town's contractor, Crossman, and Mr. Casali, the 17th of February, 22nd. So there hasn't been a ton of time. It's not like either
Yeah, absolutely.
Mr. Casali or Crossman
They're not
has
last
been
on
delaying.
response,
So,
absolutely.
My thing too, I haven't had any.
well, you got a valid point, Charlie, a valid point. Okay.
Mr. Chairman, based upon the comments by Mr. Kane, I would suggest that we continue this matter to the next board meeting so that we will have all the documentation available to us to make a proper determination in this matter.
We have a second?
Second.
All in favor? Aye.
Aye.
All not in favor? The ayes have it.
We need to continue the clock as well, get the clock running on this.
Any, is that acceptable to the applicant?
That's acceptable.
Moving to new business. 6 Batty Drive, ID 2504, public hearing. Hello.
Hi,
If you could state your name and your address?
Robin Tangway, 6 Batty Drive. ROBIN TANGUAY.
Okay. Are you presenting?
Ourselves,
Yes.
yes.
What's that?
Yeah, we're presenting for
Okay.
ourselves, and these are my children who are at 8 and 10 Batty Drive.
Okay, we'll begin with you.
Yes,
You swear to tell the truth, the whole truth, nothing but the truth?
yes.
Okay.
So, okay.
What
So,
are you looking for us to do?
We are looking to divide the property. We bought the compound, 6, 8, and 10. It was one property with the town, and we lived there together as a family. And my kids have since outgrown there and bought houses of their own. And so we're looking to split the property so that they can not have 2 mortgages and just have one. And so we've had a surveyor come, and we dug a well because there was a shared well. We separated the driveways so that there's separate driveways. We presented the documentation. We have both the septics tested because they each had their individual. And so each property has its own well. My septic is in need of replacement, but I've submitted the plan and the approval from the state for that. And we are asking for relief because of the size of the lot. And what we did, it was 1.6 acres, and we divided it evenly, so it's 0.8 something each. And so you have the plans in front of you, and
Sure. Go ahead.
So what specifically, what relief? Is it the septics or is it the
no,
setbacks?
I believe it's the zoning.
Yeah. So with the lots, the size they are, there's no issue with septic setbacks and wells and all that stuff?
Correct, all that's been done
Okay.
and submitted, yeah.
Okay.
I got a question. I grew up there. I was raised a little bit on that property, and I know the values and stuff. It's a beautiful home, and a duplex is over there. It's a beautiful gardens. That's a beautiful piece of property. You have no, like, not gonna wreck anything and put houses in there, are you?
No, so the duplex, I don't even think that would be a possibility.
Well, I
because,
don't, we subdivide, I was just wondering, that was my. 'cause
No, the
that's a
duplex is on
historical
one
piece of
property
property.
and my house is on the other.
You're just doing it for financial reasons. is what you-
Exactly.
That's what I
So
was
it-
hoping for. Because
right.
that, like I said,
No,
that's
it
a
is
beautiful piece of
beautiful.
property.
That's what, they've moved and I don't want to move, so we
Yeah.
could all sell the property together,
Yeah, it's
but
all hardwood floor.
it's-
That's, like I said, the gardens are nice and stuff. I know where the septic system is on the duplex side that's bad over near the pump house. There's a little pump house over around there. Or is it the big main house?
no, it was the big main
The main house,
house.
that one's bad too, yeah, something like
Yeah.
that. I mean, they were all stone ones in there, yeah. All right, as long as you're not wrecking anything.
No, we like the
When I
space.
saw that, it's the only thing I go, boy, why did they want to do it? I thought
Yeah, no.
financial, that's all I got, thank you. I appreciate you taking care of that property.
Any other questions of the board members of this particular witness?
Just the specific, on the, what you're looking for the relief, on all the lots the exact same size, or?
They are both the exact same size. Yeah, they split it evenly.
Okay.
But I believe the new zoning, that the surveyor originally went off wasn't up to date. So the new zoning required less land, I believe, but still, this would be a little less.
I think you just answered my question because on our town, on the town planner's memo dated February 7th, it states that it's an R20 zone. And on the plan, it states that it's an RMed with a 40,000 square foot requirement. So
So yeah, I was in,
It's RMed, it was rezoned from R80 to RMed.
RMed, so it's R20 med.
No, it's RMed,
Oh.
which is 40,000 square feet.
Okay. And so this says R20 zone on the memo.
Oh, does it? I'm sorry, it should be, on the memo I have, it says RMed on top, where do you see R20?
On the first paragraph under introduction, the subdivision above assesses plat 44.
Yeah, that should be RMed.
So it's 40,000. Okay.
The relief that they need is.
Frontage? Is it frontage?
Yeah.
Frontage, relief of, I believe it's 12.1 feet on the sublot B, 3,935 square feet of area relief, for sublot A.
So the plan department is recommending grant the frontage and area relief. Is there documentation fulfilling A, B, and C on 10.8C that we can quote and put into the record?
The A, B, and C is the standard for granting
Yeah, so
to,
we need documentation.
for, yeah. Tell us about, if this wasn't granted, how would it affect you negatively?
well, then my kids are still bound to this property instead of being able to just cut the apron strings and live on their own and, again, carrying two mortgages as opposed to just having their single-family mortgages, and then have to be landlords, which they really have no interest in either. So we have a nice couple that lives there right now that's expecting their first baby and loves Smithfield, and I would love to see them buy the property, and raise their family there too, that's.
The duplex serves the town,
This microphone. Yes.
I said, it's a beautiful piece of property.
It
The
really
duplex helps with housing too. It's a very nice place. I'm glad to see you're going to keep it that way, so.
Yeah, it served us well. I got to see my grandkids grow up
Yeah, you
next
seem like,
door.
you seem like, I trust you.
Any Any other questions of the board of this particular witness? Are you both going to provide some testimony or not? It's up to you.
They don't have to, they won't.
It's up to you. It's not up to us. It's,
I don't have anything to.
okay.
I misspoke, both lots need the same area relief of 3935 with the
In both frontage or just one frontage?
just for one frontage.
Okay.
Just a lot.
And this is a public, open up for public hearing or no? It is a public hearing.
Yes.
Okay. It's 6:45. If any members of the public have any particular interest in this application, please come forward. Not hearing anyone responding, the public hearing is closed. Any discussion from board members? Do we have a motion?
Yes, I'd like to make a motion to approve the application for 6 Batty Drive with, we're granting the, we're not recommending, we're granting the relief, right?
That's correct.
Grant relief of the frontage on one lot, the 12.1 feet, and the approximate 3,900 square feet for both lots.
And the testimony of the witness in terms of A, B, and C hardship requirements?
Yes, yes, those mark of hardship.
Do we have a second?
Second.
All in favor?
Aye.
All not in favor?
Abstain.
Abstain? Okay. The ayes have it. Thank you.
Thank you very much.
111 Tarkland Road, ID 2409, public hearing.
Good evening, Mr. Chairman. Again, for the record, my name's Tim Kane. I'm an attorney licensed to practice law in Rhode Island. I represent the owners and applicants of the subject property. As you may recall, we came forward in December for pre-app, tried to take your temperature on what we wanted to do here, and we received a favorable response. This is a very simple two-lot subdivision. It's way out on Tarkland Road. It's a 5.276 acre lot in an R200 zone. It's a large parcel, and my client is seeking to subdivide it to create one extra lot. I would submit to you that this property was zoned R200 way back in the day because there was a fear that the Davis landfill was going to contaminate this area, so they upzoned it so you wouldn't get a lot of houses out there. Fortunately, for my clients, the water didn't run this way. It ran towards Mansfield Road, hence the need for the town to put a separate water line up to Mansfield Road. What makes this property unique is it was subdivided in the early 90s. There was and I gave you guys copies of this stuff, or you folks copies of this stuff last meeting. There was a zoning resolution and a plan. And my client was aware of that because they did a title search when they purchased the property. But unfortunately, the plan was never recorded. So now we come back before you several years later. And based on the unique circumstances of this application, we're asking that they be able to create one lot out there. And that does necessitate zoning relief on frontage for one of the lots and on square footage for another lot. The plan is, obviously, you have it all in your package, and I'm going to call Water up for a minute and ask her a few questions.
Okay, well, you state your name and address,
Laura Field Swallow, 111 Tarkland Road.
and you swear to tell the truth, the whole truth, nothing but the truth.
And so you're the owner of the subject property, are you not?
I am.
And you have raised your family there, your 2 children, is that correct?
That's correct.
And when you bought the property, you were aware of via a title search that there was a zoning resolution that allowed this to be subdivided into 2 lots?
I did.
And you have subsequently become aware that the final plan was never recorded, is that correct?
Correct.
And are you doing this to make use of the land and not doing it for a financial gain?
It's not for financial gain, no. Not for financial gain, no.
And again, you haven't done anything to create the hardship for which the relief is sought, is that
No.
correct? Mr. Carlson is here, who's the engineer for the project. If you have any questions for him, we have acceptable soils test. We're not impacting any wetlands, and I submitted to the board last time we came before you an existing conditions map that showed that these lots as proposed will be substantially in conformance with most of the lots in the area. So I would ask that you look favorably upon this application, as you did when we came before you in December for a pre-application review.
You got a question for Mr. Kane?
Tim, the paperwork, who dropped the ball on the paperwork? I mean, it just sounds like,
What paperwork?
Way back.
Oh, it was before her time, I'd see it, but when you did a
I mean,
title.
I'm not
Yeah.
I'm not trying to.
It wasn't me. It was
No, I'm just
1990.
saying,
I had been
what proof-
practicing back then.
What proof do we have that it was done? You know what I'm saying?
Yeah, I have a zoning resolution right here that I gave to you guys last time. It's recorded in town hall that subdivided the lot. And I have a copy of, they don't look like they do now, the subdivision plan, but it was never recorded. It was a prior owner, it wasn't her.
Is it recorded now?
This plan never got recorded. That's why we're back before you.
So that's what we're trying to do too?
Yeah, well,
Okay.
yeah, exactly.
I'm just confused.
Yeah.
Once again, I'm a stickler for paper, because paper is like something that, you know,
It
you
was
can
a
always like say, I got the paperwork, you know what I mean?
I submitted it to you in December. It's
No,
in
I'm
your
just
file.
wondering where it went, you know what I mean?
Oh, yeah, I don't know. I was practicing in 1992, but I was not doing this at the time, so somebody dropped the ball.
Okay.
Simone, did you have a question?
What was the date on this resolution?
This was 1992.
And what was the zoning at the time for this?
It was R200 at the time.
It was R200.
Yeah.
Okay.
R200, yep.
And it's currently R200 now.
Correct.
And it's currently proposed to stay R200 in the
Correct.
future land use plan.
Yes. And again, this lot is substantially the same size of the majority of lots in the area.
Actually, it's not, if you look at it. Within the R200 zone, it's in the minority. It's in the majority as it's currently zoned. This lot meets current zoning. And you're proposing to create a lot that is non-conforming.
That's correct.
Actually, two lots that will be non-conforming, which goes against the current zoning and the comp plan. And I don't think we've provided enough documentation or argument that this is a hardship. The hardship is being created by no
Mr.
one.
Bowen, I submitted these last time. I'll pass. These are assessors maps. I've checked off the lots. And with all due respect, I made the same presentation to you in December with the same things. And I took your temperature before we went forward and spent a lot of money doing this.
Well, my temperature couldn't have been taken because I wasn't at the meeting.
I apologize.
And I did review the video and reviewed the minutes.
Okay.
But I didn't read any temperature that this was a positive
Well,
thing
I
to
would-
move forward. And in fact, I believe it will create a precedence going forward for our 200 zone,
Well, you
or
don't,
any zone for that matter, Tim, Mr. Kane.
well, you don't sit on the zoning board, but you're acting as a zoning board now.
Yes, we are.
So each case that you hear it's distinct, and each case is driven by its own facts. And you don't set precedent in the future based on the facts of this case.
Yeah, you stood before us on a number of occasions and referenced cases that you prior represented, and you base your...
No, I haven't.
Yes, you have.
What
I've been here long
Really?
enough to know that.
You cite those examples. What I will tell you is you want to be fair and consistent to anybody that comes before you, but each case is unique. This is a unique case, all right? Given the history that I gave to you and that I gave to the majority of the board last time.
I respectfully disagree with the attorney.
If there was a recording,
Pardon me?
if there was a proper recording that was not done in this case, would we be talking today?
We wouldn't be here today.
Uh-huh.
If it
I
was
rest
done.
my case.
And my client, it's not her fault.
That's-
She's trying to make a reasonable use of the property, and I can pass these maps around, you can all pass judgment, and I would argue that this lot is consistent with the majority of the lots in the area.
And yet it goes against zoning, and the applicant is currently making use, the proper use, the legal use, a conforming use of the property today, and it meets zoning. It's in conformity.
He's got a point. I didn't even pick up on
He has a
that.
point, and you are a relief valve for people. Now you are, and you're not used to acting in this capacity. So this is new for you. You're acting kind of as a zoning board now. And so you are a relief valve for unique circumstances where people come before you, and you have the discretion based on the individual facts of a case to grant relief. That's
There
why
is
you're
no
sitting.
hardship here. There's no hardship.
I agree.
The only hardship is that
And-
it's conforming to the current zoning. And you want to do something that goes against the zoning, so that's the hardship. It's pretty clear. I mean, I've read enough cases.
Mr. Moen, in your opinion, there's no hardship, but we argue that there's a hardship, and there's a history where this was subdivided, and it's a common sense application, and it is consistent with all the lots in the area, or the majority, despite what you said, with no proof. Okay, and that's why you're going to see these. You're going to see these from time to time, and it's up to your discretion whether you think it makes common sense and it's good planning. And I suggest if we can easily get, these are good-sized lots, I would suggest they're probably 4 or 5 times bigger than your lot, Mr. Moon, 4 or 5 times bigger than your lots.
Something, this attorney is making this personal in regards to referencing the lot I live on.
Well, I would suggest that,
No, I'm being singled out here.
no, I would suggest
We're
that
not
they're 4 or 5 times bigger than the majority of the lots in Smithfield, okay?
Just listen to me for a second. Either council or the board, we're not going to get personal, we're going to talk about this application, okay?
Yeah.
That's what we're here for, so let's.
I would-
The issue that I have that's a bit contrary to your thought is the fact that the zoning had approved of this, just the same exact thing. But for an error, they would be able to do it in terms of the filing. That's what I'm struggling with. Right, because a zoning board apparently heard the same type of application, whatever the evidence was, and came to that conclusion that in this particular case, it was appropriate. These people would be able to do it, but for someone dropping the ball and putting that piece of paper Charlie talks about on the record.
Can I say something?
Mr. Chairman,
Well, Charlie, go first,
I would
because
just
he
like to
asked.
say, when the property was bought, wasn't a title search done on this? So you
It was, and
you should have been aware of this and changed this a long time ago.
A title search was done, and in the title search, you're going to find a zoning resolution. My pen's hanging out over here.
Then
You're
I would
going to
like,
find a zoning resolution that leads you to believe it would create two lots. Not every title attorney, a lot of title attorneys, not land use attorneys. All right? They do title searches, and if you look at this, you can say, hey, you got 2 lots there, all right? But they're not good land use attorneys, and they miss things sometimes. They miss merger all the time, title attorneys, merger of lots, contiguous lots, because they're not zoning attorneys. So again, let's take the helicopter view. Can we get a well? Can we get a septic? Can we get a house on the lots? Do the lots have good physical access? They do. They're right on the street. Are we altering the general character of the area? If you want to get hyper-technical, acting as a zoning board, you can deny just about everything that comes before you. I would respectfully suggest that's not your role. Your role is to give reasonable relief when it's called for, and I would respectfully suggest in this application, it's appropriate for you to give reasonable relief.
I would just like to finish. What is the legal, what does our lawyer have to say about it? I mean, maybe we should postpone it since we get the paperwork, find out what's really going on. And once again, paperwork, let's just postpone it You say you can get, wait, you got proof that the title was on the title from the title insurance or whatever? the title-
I'll submit this as part of the record. This is a zoning resolution
Let's-
recorded in land
let's
evidence
work- let's
records.
start
It's a
working with that
public
then. He
record.
does bring up a point about that, though. I mean, I didn't even think about it, and I look at things like with a microscope, and I'm looking at, it doesn't
I
really
mean,
conform.
I did come before you in December, before we went this far. We talked about these issues, and the consensus of the board, and Mr. Moore wasn't here, was it looks good, go forward.
But
or else we
we're
wouldn't-
always thinking though, Timmy, you know what I'm saying, like that? That
But
doesn't mean-
nothing's
just because we didn't
changed
think about it last time, doesn't mean we can't think about it this time. Before we put the little pen down on everything. we
Nothing's
should
changed
think
between
about
now and
everything.
December.
I'm just saying the legal aspect. He does bring up, a little bit,
Joe's got a question or a point.
So I would like to talk to our attorney, what he seems, that's my point about, that would help. What do you think?
So, as a board, you're simply charged with determining if the facts of this case meet the elements for both the zoning and subdivision regulations.
Yeah, but we have a missing football, though.
No.
We have to believe that's missing. The paperwork's missing. We have, no, I'm just saying, we haven't seen it. It's like that proof to look at. If you look. Well, then what we talk, I mean, you keep saying that we.
Here it is.
It wasn't ever
It's a
recorded.
zoning
Was it
record.
recorded or not recorded? Does he,
That a-
what is the?
Mr. Chairman.
Where is it?
Yes, Joe.
Here's my question. Mr. Kane, you're a land use attorney.
Correct.
Okay, you've done this for a number of years, am I
Yes.
correct? Okay. You have a valid change that was done by a zoning board in 1992.
Correct.
You have it in your hand. What stops you from recording that today and going away and doing whatever
Because
you want to do?
They did it primitively. They recorded the decision, but never recorded the final plan. So we have to come before you, and we have to go through your processes now, which are much more involved than were in 1992.
So other than the fact that it was recorded, this would have been two lots that would have been operating in the town of Smithfield from 1992 forward.
Correct.
Let me just clarify so everyone understands what was recorded. The zoning board back in 1992 heard the application and makes a decision. It's called your zoning board resolution.
They granted the same relief that he's looking for today.
They granted it in a resolution. The resolutions get recorded. That's what Attorney Kane is going to submit as the exhibit. What never got recorded was the actual plan. These plans that you see all the time as a board that's up on that screen right now. The plans get recorded through the planning department, they bring it up to the clerk's office. The plan wasn't recorded. Resolution deciding it was recorded. According to the planner, plans, the actual plans need to be recorded within 1 year
So I'm gonna,
of the resolution. So he can't now go to the town hall and record the plan that matched that resolution, because it's too late. But the resolution still remains on record.
One question for you, so like that. So when does the paper become legal? When the clerk stamps it?
20 days after that resolution is recorded. The appellate period runs that resolution.
So it's not an official, there's no official piece of paper then?
That is the official piece.
But what, did it go to the, that's why I asked, my question was, when does, the resolution was passed, but it didn't go through the clerk's office?
No, it did, that's what I just said. The resolution was, the zoning board made the decision called the resolution. The resolution's reduced to writing, it's brought to the clerk's office after the chair signs it, and it's recorded. The moment it's recorded, it's official. 20 days to appeal that resolution. If it's not appealed, the resolution is final at that.
But it wasn't recorded though. Was it?
Resolution was. The
The
plan wasn't
plans was,
recorded.
yes.
The resolution was.
It's
I
two
got it.
different things.
No, I'm just saying, that's why I'm saying we should just look, let's just.
That's why I
What is that?
explained. The decision, resolution to allow it to take place was recorded.
The same relief they're seeking today.
Same,
That's the
Has a copy of the resolution.
So, Mr. Chairman, question. So why does the drawing take more priority than the written decision?
I don't know if it's the drawing or not. I think they need the drawing to go forward
That's a very
with,
good point, yeah.
with the plan, and because there was no drawing, They're back here.
I don't think anybody's gonna let her, this is the unrecorded plan. I don't think the town planner in 2025 is gonna let me take this plan from 1992 and record it. That's why we're back before you. We're asking you for the same relief that the zoning board granted in 1992, that when she did a title search, it's gonna come up in the title search, and it leads you to believe you could have 2 lots out there.
Okay.
Again, they're big lots, they're in conformance with the area, you can put a well and septic on them, I don't think anybody's here objecting to it. It's a common sense application. You get hyper-technical, you can deny lots of things. I would respectfully suggest your role is to be reasonable and grant relief where it's appropriate. I think given the facts of this case, it's appropriate.
Okay.
This is the unreported, very clear.
Did you have a question?
Do we have to abide by this recorded resolution?
No,
I mean, is this making our decision mute?
it isn't, but it's instructive.
It's instructive. Okay, so
In
we
my
could
opinion.
disagree with I haven't read it, but we could disagree with it because Attorney Kane's argument, you could put a house on every 40,000 square foot parcel in this town. I mean, why not?
That's
Why-
not my
I'm
argument,
talking,
Mr. Moan. That's not
All
my
right,
argument.
one at a time, please.
the argument could be that R200 is not appropriate for that area. Why not rezone the entire 200 conservation zone?
The issue I have with it is the same exact relief was granted by a zoning board back in the 1990s. But for someone's error, it has created a hardship to these people who, if they did their title search, they would have seen the zoning document, but would not know that they couldn't build because the plan was not with the title.
So that's the hardship.
I got a question.
In part,
That's the argument that the
yeah,
hardship
in
is.
part, of course. It's not like they're just coming here saying, hey, we want to subdivide this. They're coming here saying, hey, when we bought this, there was documents filed by a prior zoning board that said, hey, we could do this. And that's why I think this is different than the run-of-the-mill case where someone's just coming seeking relief in day one. That's how I see it differently.
Okay, thank you for that explanation, because that makes more sense to me. Thank you.
I have a financial question. How's that been taxed at?
Pardon me?
Does it make a difference in how that's been taxed all these years?
It's been taxed as one lot. I'm not gonna tell you. It's been taxed as one lot because the subdivision
So
plan never
then,
got.
do we pay back the tax? Here's,
No, John, there's case law on that, the tax assessor decisions is, I'm telling you, there's case law on this. What is a property is zoned for versus what it's taxed at, are two separate things, you cannot utilize the same. It happens all the time, people come in and say, oh, the town has this listed as a 3-family, but they only have 2 units, they want to increase it to 3. It doesn't matter what the tax assessor has, zoning and tax are completely separate, there's case law on that. Do not use what it was taxed at as a reference point to whether you can grant zoning relief.
I'm just asking the question, was there a financial gain on not having this brought up before? Why did we wait all this time to bring this up now? You know, why wasn't it brought up before?
I think Mrs. Swallow, when we were here last time, mentioned, if I'm correct, that the plan is, I think you have a son that's in college, that's
Right.
graduating, and the
It's
plan
kind of
is
to
to,
entice him to, I'm sorry.
the plan
So he
is-
would- Yeah, he's going to graduate from UR this year, and he's going for his master's at Bryant. Loves the area. We'd love for him to stay close to home. So the game plan is, he still kind of wants his own space, and we'd have something kind of separate from him. So, and when we did purchase the house, it was understood at the time, everything was recorded, and that we did have the possibility of using 2 lots. We just never had the desire to, because, when the kids were younger, we had the land and so forth or whatever. So it's really just a matter of things changing. So we never really looked into it any further at the time.
okay, Charlie's looking at the exhibits, and
I-
look,
yeah,
go ahead.
My question is, when the zoning board gave that relief in 1990 or 92, was the zoning around that area different, and that was an influence on their decision? Has it always been the same?
In the resolution, it says it was out.
Yeah, it's always been that.
Yeah.
Okay, thank you.
And we're going to mark the resolution as applicants Exhibit A, the plan applicants B.
I got a simple question. Mr. Adler's here. What does he feel about all this?
It's not on a butter. I don't think he cares. I think he's here on something else, on the.
Well, I'm
on the
just saying,
farm.
because that's his driveway. Well, I mean, not his
No,
driveway.
no, that's the next application, Charlie. That's all.
I'm big on jumping. Too many lawyers involved. I just happened to see him right there. That's all. Well, if it's legal, I don't know. That's the whole thing.
It's marking it as exhibit.
Yep.
That's the original thing.
Just by way of some more context regarding the zoning, in 1987, about the zoning townwide change, there were a lot of lots that were R80, and I'm assuming this area as well is probably zoned RR, which was R80 at the time. And after the 87 rezoning of the town, this was zoned R200. Primarily, as Mr. King pointed out, because of the proximity to the Superfund site. As he pointed out, the groundwater plume that's associated with that is running north and northeast away from this property. Is not thought to be in this area at all. That's primarily the reason this was zoned R200.
I think that's some of the history that we received last time. They're just taking a look at the resolutions.
Mr. King, I have a question. Where do you want these?
We're going to give it to the town planner.
The resolution itself was recorded.
Correct.
The plan, not recorded.
Correct.
Do you have any speculation as to who was responsible for recording that plan?
I have no idea, sir.
Okay. But for the
But it
fact-
wasn't my client.
I know it wasn't your client. Your client had a title search done,
Correct.
and the title search revealed the resolution that was in the land records that
Correct.
said there was the ability to split that lot into two and put two houses on that property. Am I correct?
That's absolutely correct.
That's when they purchased the property, that's what the title search revealed.
Yes.
Okay. And subsequent to that, she has now found out that the plan was not recorded, and therefore she could not go forward with the planned two residences on that property.
That's correct, without coming back to you.
Okay. Thank you.
Thank you.
We're going to open for public hearing. Okay. Any other presentation or testimony?
No,
Okay.
I think you know the area, and I think this proposed lot would not alter the character of that area. There's plenty of 2-acre lots in that area, including the 2 lots to the immediate right of the property, as you stated, it's the same size.
It's 7:13, open matter for public hearing. If anyone has an interest in this application, please come forward. Not hearing or seeing anyone respond, we will close the public hearing at 7:14. Any discussion, board members? Do we have a motion?
Mr. Chairman, I make a motion that we approve this plan, and the record reflect that, in fact, the relief granted by this board is the same relief that was granted in the resolution that was recorded in the land evidence records back in 1992.
Second.
All in favor? Aye. All not in favor? The ayes have it.
Thank you very much.
Next matter, 49 William Road, ID 2503, public hearing, minor subdivision, preliminary plan review.
Good evening, Mr. Chair. For the record, this record of this case, Tim Kane, and I represent the Donovans. John and Patricia, and they're here tonight, and they'll be testifying briefly. So what you have before you, there is a typo on your staff report, and it came to my attention this afternoon reviewing staff reports. This property is located in the R medium district. And because we don't have water or sewer, the lots have to be 65,000 square feet each, and they both exceed 65,000 square feet. The Donovans live on the property. They want to downsize. They want to build their retirement home, and they want to stay in Smithfield. And so what you have is a 3.41 acre parcel, and the two resulting parcels would be, one would be approximately 68,000 square feet, which would exceed obviously the 65,000 square foot minimum, and the other parcel would be approximately 80,000 square feet, which would well exceed the 65,000 square foot minimum. So we meet the area requirements. What we are asking for relief on is frontage. And when we originally filed, we were under the mistaken impression that it was R80, and we asked for lot size relief, and I'm glad we don't need that. We don't need lot size relief. We have the 65,000 square feet. What we do need is frontage on each lot. Parcel A would have 32.4 feet of frontage, and we need 170 feet of relief. And parcel B would have 140.9 feet of frontage, and need relief of 9.1 feet. So I would submit to you that the lots meet the zoning requirements of area. They don't meet frontage, and I would ask, and my client is not doing this for financial gain. It's not going to alter the character of the area. We meet the zoning test. He's going to come up and testify to that briefly. And when you consider frontage, I think your primary view on frontage should be, do we have good physical access to a street? That's kind of the primary purpose for frontage, or one of the primary purposes, and I would suggest that we do. I'd like to call Mr. Donovan up.
The relief for the first one is how many feet?
So I'm going to submit, so when this came to our attention, you can pass these around so we all have it. So for parcel A, we're asking for frontage relief in the amount of 117.6.
117 feet?
117.6. And for parcel B, we're asking for relief on frontage of 9.1 feet. I keep saying square feet, it's feet, I apologize. Oh, okay, all right. Okay, so I'm revising it again because there's a revised parcel A has 40 feet of frontage, so we only need 110 feet of relief. And parcel B has 150 feet, so we don't need any relief on parcel B. So we only need relief of 40 feet on parcel A. Which is not what you have in front of you. I apologize for that.
I kind of thought there was a mistake. I
Yeah.
did my own little math,
Yeah.
I usually figure out, I give out with 107 and go.
Yeah. So one more time, parcel A, we need 40 feet of frontage. Is that true, Mr. Carlson? I want to get this right. And parcel B, we don't need any frontage. So I'm going to put Mr. Donovan on.
Can you state your name, please?
I'm John Donovan, 49 Williams Road.
You swear to tell the truth, the whole truth, nothing but the truth?
I do.
Go ahead.
Mr. Donovan, how long have you lived at this property?
I've owned it since, Dad asked me that, huh?
Yeah.
It's been over 30 years.
And did you raise your family there?
I did. I have two daughters that, actually, one lives on Williams Road, The other one was on Old County Road.
And what's your desire with regard to cutting off a lot? What's your plan?
Well, the current house is too large for just my wife and I, so we're looking to downsize.
Okay, and so you're not doing it to make money, you're not doing it for financial gain?
Now, I mean, if I could sell the house, it'd probably, with today's prices, hopefully I can break even.
And it's your desire to stay in this house with?
Absolutely.
Correct? I don't have any questions.
Because I have grandkids here, so.
And you're familiar with the area, and you have an opinion as to whether this would alter the character of the area?
Oh, wouldn't alter it at all.
I don't have any further questions.
Any questions of this particular witness by the board? Any other testimony?
No.
Questions of the board? Any discussion?
So can you put up the driveway? Is the driveway going to be shared on the new lot?
It is not. Sure. Paul Carlson, Insight Engineering Services.
This way, and you swear to tell the truth, the whole truth?
I do. The proposal is to have the driveway as a separate driveway.
To the existing house?
To the new house, with the existing driveway still being able to access the existing house.
So the driveway for the existing house is going to be part of the new division?
No, the existing driveway will remain on the lot that has the existing house. There will be a brand-new driveway to access the rear of the property.
Okay, it looks like that the driveway,
There's a small portion of it or a sliver of it, but the majority of the lot will be on the existing lot.
Any other questions of the board member? Of the board members?
I can see from looking at the plan how it could be confusing, Richard. It's,
My apologies. It does, yes, it does indicate and does show that it is on the other property. My apologies in stating that. Mr. Donovan would have a shared driveway for that first 100 feet, and then it would pair off. So there would be an easement that would be required for the driveway for that lot B. My apologies. If he chooses to maintain that driveway as is, it could be relocated, but it doesn't make any sense at that point.
Any further questions? Discussion? Okay. Could ask the question. Do we have a motion?
so I do have a question. We're creating a separate lot, and the question was asked is that this is not for financial gain, but obviously we're creating another lot.
Correct.
So how do we determine whether or not it's not financial gain when you're actually creating another lot?
As I understand it, the primary intent is not financial gain. Of course, it's two lots. As a practical matter, two lots could have an increased value, being practical. What they're saying, what I'm getting from the presentation was the intent is not to do that, to just sell for gain as opposed to the other reason that they've given to go forward with this particular application.
Okay.
And by the way, we work with financial gain for the last 20 years. That has been removed from the test. So I like to put it in there just to show he's not doing it to make money. He's not a builder. He's not flipping a house. He's looking to build his retirement house. But the financial gain you no longer see in the zoning test. It's removed.
So, yeah, so here's the financial gain, I had to make sure. The previous standard for zoning was, what part of the standard was that it wasn't primarily for greater financial gain. That was part of the standard. That standard's been amended with the new land use regulations that has been dealing with for about 2 years. That standard has been removed. So we have to.
So it's a non-factor in our analysis, one way or another.
He just benefited his own retirement.
I'm sorry?
He's just benefited his own self, that's it. Not financially.
Well, what Mr. Ursillo is saying is, even if the
irrelevant.
applicant intended for financial gain, that's not a factor for us to use to either deny or approve the application.
Okay.
Under the existing law.
Great. It's much easier. Thank you.
Well, that was part of the problem. I have a lot of zoning boards like that. But there was an analysis that had to be greater than normal finance.
What's normal?
Took it out, so exactly.
Whatever you want it to be.
But we're still justifying dimensional relief, and in this case, the property meets most of the dimensional requirements except for frontage and width, which is an easier, at least in my opinion, bar to overcome.
It is, absolutely, I agree with you. It is, when.
We agree on something
We
tonight.
do, Mr. Moan. I know areas of concern, and I think the last case was unique, so I feel it's more comfortable for me to come in with a case like this where both lots meet the 65,000 square feet. I would say that.
I'm sure it is.
Yeah. So again, we're looking for just relief on proposed lot of 110 feet.
Mr. Chairman, I can support this one.
Okay, would you like to make the motion?
It's a public hearing.
Thank you. With no other questions of the board members, we'll open this matter up for public hearing at 7:26. Anyone, member of the public that would like to be heard on this matter, please come forward.
Oh, hi.
Please state,
My name is Matthew St. Louis,
and where do you reside, sir?
55 Williams Road, the next plot over.
Okay, let me swear you in.
Yep,
Do you
sure.
swear to tell the truth, the whole truth, nothing but the truth?
I do.
Okay.
So I have not been there very long. I've been there for 4 months with my family. Unfortunately, I don't have a full view of what an entire year looks like at 55 Williams Road. So I do have a couple concerns about how the possibility of this development would affect the characteristics of my property. Mainly just rain, water runoff, potentially increasing the amount of moisture that I get. My structure that for the house is recessed much further back behind where Mr. Donovan's property is. So it looks like whereabouts the new driveway that would come down is about even with where my structure is on the far side. So I guess my concern is, having a study on how exactly that could negatively affect my property.
How this development may or may not affect primarily water runoff into his property, is that the question?
And to note, we are at the top of the hill of Williams Road, so where this planned driveway would come down would need to come downhill equal to the, grade that my driveway and my property is recessed downhill.
The property's on the right-hand side of it or in the back? I'm confused.
It's where the mouse pointer is. It incorrectly says David Gagnon, since we're still relatively new to the street, but
Can you bring up the other one where we showed the subdivision and show where that would probably be?
Property is here. I don't want to speak for.
If you can help us with the topography?
please.
The topography runs from William Street and runs on a easterly direction. The proposal or any of the driveway would run westerly all through this area. There would be no surface runoff that would be directed to the north. Everything would be directed towards the to the east. And as part of this work, we are proposing stormwater effects with swales, grass swales along the driveway. There will be stormwater features around the house, inclusive of underground infiltration systems, rain gardens. There will be a a number of items that will be included as part of this proposal and will be actually submitted as part of the site plan to the town engineer as part of the project.
So you have thought about it?
Yes, we have.
Do you have any questions of what was said?
I do not.
Just in case you don't understand what you're saying, they're gonna get it. If you still don't agree, then we can stop this at another point.
Sounds good. I appreciate you explaining.
Yes, I'm just saying, it's not open, not open. Because we don't even have it yet.
Mr. Kane, you need a moment, or? Okay. Thank you.
Thank you.
Anyone else from the public that would like to be heard on this matter? You could state your name, your address, then I'll swear you in.
Eric Benante, 108 Log Road, Smithfield.
You swear to tell the truth, the whole truth, nothing but the truth?
Yes, I do. Benante, B, as in boy, A-A-N-A-N-T-E. All right, I live right at the bottom of the hill. You can see Eric and Melanie Benante on Log Road. So my only concern is just the water runoff and erosion. I just want to make sure when you guys are looking at these plans that you're taking that into consideration. We do see a lot of.
Can you tell us where you are again?
108 Log Road.
Okay.
And this area here.
Yep, right there. Yep.
So. You're on the left-hand side coming out of Williams Road.
I'm actually right across the water on Log Road, on the bottom. I'm not on Williams Road.
It's on Log Road.
I'm on Log Road. I'm on the very bottom. Yep. So, I mean, that's my main concern is the water runoff. I mean, I know on occasion when we have these big rains, the water does flood over the road, you know, so, I mean, if the water, when you're creating a driveway, you could potentially create a situation where you have like a river now coming down from Williams Road, from that area. I know further down on the corner of Williams and Log, they did build a culvert, some large ditch system, because they were having problems with water coming down that main road. So I don't know if that's gonna create a similar situation when this driveway gets built, so just a concern of mine, you know, because I am right directly on the bottom of this new development.
Can you address?
Can you address the requirements?
Nice to meet you. I certainly can. Very similar to the previous butter. What we have as part of the driveway is a series of swales. So each of the grading of the driveway will be directed towards the grass swales, which will slow down the water. We will have a number of other stormwater options along the driveway that will slow that and manage the stormwater. In addition, as you can see, there will be a very limited amount of disturbance within that property. The majority of that lot will remain as it is, as a wooded area. And with that alone, there will be almost 300 feet of woods even prior to getting to that abutting property line. So there's a few items here that will certainly help and mitigate that stormwater.
I got a question. What does the driveway consist of?
We look at it from an engineering standpoint, the worst case scenario, which is a pavement. What Mr. Donovan chooses to do, I'm not sure at this particular point, but we look at it as a paved structure.
And you would have it pitched to go to the sides anyways, correct? You wouldn't have it shooting down.
Correct. It would be super elevated to one side of the driveway, such that it's all being directed towards a grass swale structure to slow that down.
What is the grade for that, do you know?
Along that edge of the driveway, the first 300 feet, you're probably looking at about 10%. It's fairly steep through that segment, and then it levels out as you work your way around.
Yeah, the hill there is very steep.
But you are,
The concept of the water will roll off is what I'm saying to you. In other words, it won't come down like a flume, or there's a driveway with that kind of a pitch.
No, and then like I said, it will be pitched downward, but it will also be pitched towards the side.
That's what I'm saying.
That's what the intent would be. Yes.
But you are required as engineers to design so that when you do develop the property, that there is no increase in runoff to adjacent properties.
That is correct, and as part of a site plan to the town of Smithfield, we do have to show those particular items along, as part of the submittal to the site plan.
So if you do see additional runoff, you have recourse because they need to design the system so that there is no increase runoff onto your property.
Okay, yeah, that was one of my questions too, if there was any recourse, if they were to develop.
Mr. Kane, do you agree?
We can't increase runoff. Everybody knows that. We have.
I think that just should be stated because you've had a couple of questions now on this.
So for the record, nobody can increase, no net increase of runoff on property, and the protection you have is, you have a soil erosion ordinance in the town of Smithfield, and that's got to be complied with. Before you pull the building permit, you have to submit plans, and it has to be approved by the town. So there should not be any net runoff if the proper engineering techniques are adhered to, which they will be.
Thank you.
Thank you.
Anything else?
That's it, thank you.
Okay. Any other members of the public that like to be heard on this matter? Not
By
here.
the way, what I passed out to you is correct. Correctly, we're seeking because it's lot width and frontage that combine, and you measure width at the setback. And so that's why we have those calculations for you. You can see how it narrows in a little bit, so when we get back to the setback, those are the dimensions that we use. So we ask you for a little bit of relief on frontage, parcel A, on parcel B, and more relief on parcel A. Frontage on both lots.
So 110 on A?
No.
What are the numbers?
A is
40 feet.
117.6 because we measure at the setback.
So you're back to where, okay.
We are.
Okay.
I knew I was right.
I was hoping I was right.
And on B,
Did
and on B 9.1?
And B is 9.1.
did I close the public hearing?
No,
No, you didn't.
we didn't.
Well, out of abundance of caution, to the extent I've already closed it, I'll close it again at 7:37. Any discussion?
One question, the existing driveway, are you going to be relocating that to, out of the new parcel?
Sorry. I'm not sure I understand what you mean, but we'll widen it so it'd be one going down. Is 100 feet?
What, Mr. Moen is asking, the existing driveway that's there at this point in time, is that going to be changed?
Relocated?
No. No, it can't because of the way the house is.
So ultimately, the question was asked prior to, the existing driveway for that first 100, 150 feet will remain as is. That will be the primary access for both lots. After that will be the new driveway, which would be constructed to gain access to the new house. So there will be an easement that will be associated with the existing house for that portion of the driveway.
Gotcha.
Any other discussion?
Can we just, I want to just make sure we clarify what we, there's two, there's frontage and there's width. The frontage is a different part. What's that? You have to decide frontage and width. If you just did width,
The zoning ordinance calls it lot frontage and width together. Okay? My understanding is you measure that setback. So I would like to proceed out of portion because we have 150 on parcel A, but when you measure at the setback, it's not. Okay, we need 32, on parcel D, you have 150 feet of frontage, but when you measure at the setback, it's 140.9, so we're asking for 9.1 feet of relief on parcel D. And on parcel A, well, we have 40 feet at the street, but when we measure at the setback, it's 32.4, so we need 117.6 feet. You expanding. It does. Okay, so we measure that setback. We're asking for the most.
Put it, make it frontage.
We're gonna leave the frontage on that anyway.
Let's make the condition that the frontage will be at whatever distance the engineer says it is. That way, there's no misinterpretation that width relief can also be classified as frontage.
See,
Probably you can have your frontage relief here, 20 feet, but then the property narrows over here for a short section, and they need more width. At that point, they could use their width. There's a lot of relief to make their frontage narrower too, to match that width. I wanna make sure the frontage is at the level that they say, even though the property narrows. Is that what I'm understanding? The property narrows as you go in.
correct.
So you want the frontage consistent with what they're showing there, so that Mr. Donovan can't later come back and say, well, I got width, greater width relief, I'm gonna apply that to my frontage too. Frontage and width are two different things, even though they're right together. I don't want the frontage to be interpreted as being
Is the intent to get any relief other than what we normally refer to as frontage?
No. Well, width, okay? Width, because you measure width at the setback. So if I ask for that, it's the greatest, we would always ask for the most relief requested, so I think it covers everything, in my mind, you know.
And I recommend that the board just make sure a condition of the granting of that relief is that the frontage distance is, this engineer, what is it, Mr. Townsend? What is it?
40 feet. It's 40 feet for lot A, parcel A, and 150.21 for parcel B.
That's frontage.
Correct.
So that way, although you're granting with relief, your condition is that the frontage has to be the 40 and the 150.
40 and 150?
40,
2.
A and D, 150. So, parcel B will be 150 feet, parcel A is 40.
That's correct.
Excuse me, Mr. Chairman, resulting in a requested relief of 117.6 feet on parcel A
Correct,
and 9.1 feet on parcel B.
correct.
You want to take that one, Joe?
Ready?
You're going to take that one, Joe. You got it down.
Be my guest. I thought we were gonna pass this.
Huh?
We are.
I'm not kidding, Stuart.
Mr. Chairman, I make a motion that we approve this request, okay? And that the resolution include a requested relief of 117.6 feet on parcel A with a frontage of 40 feet, and the request for parcel B being relief of 9.1 feet in frontage of 150.21 feet.
That works. Confusing?
We hear the 117.
You've made sense out of it, so thank you.
Second. You need to add the 117.6 on the width. I didn't hear that.
I did.
You did he? Okay. Never mind.
Did he get the 117.6?
Yeah.
Okay. We have a second.
Second.
Yes, he
Yes, twice. Just in case. Do we have a second?
Second.
All in favor? Aye. All not in favor? Okay, the ayes have it.
Thank you.
You're welcome.
Stack. It's going to get
You guys-
smaller.
You guys want to take a 2-minute break or keep rolling?
Let's take a break, a little break. Yeah.
We're going to take a 5-minute break. We'll get back at approximately 7:50.
Wow. We got 3 more. We got 1, 2, 3. 3 more. Yeah. I don't know how we do.
Never had to do that before. Which one? The one we just did.
When they sent out the request, see if everybody wanted to move it, she said no. You have a question? No. You look like
I did have a question about that. Last resolution and the map. Why did they refuse the map at this point? Because it wasn't done within a year?
Yeah, they have a year to report it after the decision.
Okay.
They just got it, who knows why, maybe they.
They probably,
I think they.
they probably didn't know that.
No, I mean, it's been pretty settled. You have to report. Reporting is really the thing Anybody? We've advertised positions, so
Good for you.
we got a small farm in Gloucester. Hang out with some cows.
Congratulations. Wow. I got a feedback on that here. Landmark Road, 218.
Yeah.
People are.
They're gonna be things that are revised. They're gonna come back to the TRC, much reduced plan.
Fair enough.
Yeah, it was state allowed.
Sure.
Wasn't it? So it's gonna be a lot less.
I understand they've organized like a movement, the community, they've had meetings, official sign and everything else. Oh. Thank you. I don't see him.
John's here. Jack. Al's right there. Let's go. Come
Want to start without him or?
Give him another minute. Use labor relations connection.
What?
Use labor relations connection.
No. No, I don't think that's true. I don't have
Arbitrations?
No.
Just wondering.
No, not the stuff that I do. We don't see that. Usually the lawyers pick them.
Yeah.
Yeah.
I used to use AAA a lot.
But most will agree, like I do, 50% of what I do now is act as an arbitrator mediator. 20-50%. I get along both sides. No, any litigation, civil litigation, bodily injury, property damage, stuff, you know. Mediator. I do both sides. That's right, that's right, that's right. We ready? All right. Okay, it's 7:56. We're going to go back on the record. Next matter is 17. Please be quiet. 117 Mapleville Road, ID 2501, public hearing, minor subdivision, preliminary plan review.
Good evening, Mr. Chair. Last one for me tonight. I represent the applicants and the owners. This is a two-lot, it says one existing lot, that's 8.15 acres. It's a large lot in R82 acre zone. And
Hang on. Can we please be quiet? There's a presentation. Thank you.
And this lot is in the middle of the Adler family farm, but it's been owned by the Keegans forever, and they have quite a good relationship with the Adlers. And they want to cut off a lot, 2-acre lot, so their daughter could build a house on the lot, and she'll testify to that briefly. And I believe the only piece of relief we're looking for is frontage, 40 feet of frontage. Otherwise, it meets all the requirements. So I'm going to have, I know everybody's here and they don't want to speak on this. I'm going to have Brianna Keegan come up briefly.
Hi, how are you?
If you could state your name, your address,
Brianna Keegan at 117 Mapleville Road.
okay, and do you swear to tell the truth, the whole truth, nothing
I
but
do.
the truth?
And how long have you lived at 117 Mapleville Road?
Since 2009, my dad built our house.
Okay, and you're desirous of having a lot cut off from the family property, a 2-acre lot. What's your intention with regard to that property?
Just basically start a family with my boyfriend and stay local with our family. We love our neighbors. I honestly can't imagine leaving the farm. The thought of leaving the farm is kind of scary, honestly. So when the opportunity was presented by our great aunt, we definitely wanted to see if we could do it.
And you haven't done anything to create the hardship for which you're seeking relief, have you?
Nope.
And you're familiar with the farm and the house, all the houses on the
Yeah.
farm?
We have a good relationship with a lot of our neighbors.
Okay, and did you work with the Adlers to try and design a location of the lot so it would have the least impact on their property?
Yes, before we even started the process, we actually met with a few of the Adlers to see what their thoughts were and concerns, and we kind of have a good agreement of what needs to be done in order to put a piece of a house on that property.
And in your opinion, you're not going to do anything that would alter the character of that area?
Absolutely not. The place is beautiful. I don't want to change much of it besides put a house that I can start my family on.
So thank you. So again, it meets all the area requirements and of an 80,000 square foot lot, and the resulting lot would be quite large still, and they're only asking for 40 feet from the 200 foot requirement.
Thank you.
Any questions of the board members, beginning to my far right?
So, given the excesses of someone's driveway, do we need an easement? Right away.
Your code allows a private road to be considered as frontage, and they have a deeded right-of-way to use that private road, and that private road serves many houses on the Adler farm.
So there wouldn't be an issue if there was a falling out or if she sold the property and that Mr. Adler couldn't come back and say,
No, the Keegans have a deeded right-of-way to that property.
okay, thank you.
Michael, any questions? No. Now, 8 o'clock, we'll open this matter for public hearing. If any member of the public would like to be heard on it, please come forward. With no one responding, we will close the public hearing at 8 o'clock as well. Any discussion?
I do have just one curiosity. Why wasn't just curiosity, why wasn't the new property line shot all the way back to the original parcel? To divide it completely in half. Right, I know there's wetlands back there and stone walls, but just a curiosity why it wasn't.
If you could state your name and address, please.
My name is Donna Keegan, 117 Mapleville Road, Greenville, Rhode Island.
Swear to tell the truth, the whole truth, nothing but the
I do.
truth? And you could answer.
Yeah.
This provides 2 acres.
If we just stopped, like where we stopped, we didn't go all the way back. That's to maintain the property.
The original parcel?
Yeah.
Okay.
Yeah.
I'm not familiar with, what's back there.
Yeah, no,
except what's
it's
on the-
just the 2 acres that are necessary by code. And then that maintains some property back there.
Got you, thank you.
Any other questions or discussion? Do we have a motion?
Yes.
Mr. Chair?
Oh, go ahead.
Go ahead, Scott.
I'd like to make a motion to approve the 117 Mapleville Road application with the relief of 40 feet on the frontage.
Do we have a second?
Second.
All in favor?
Aye.
All in favor? The ayes have it. Thank you. Next matter, 20 Esmond Street, ID 2502, public hearing, minor subdivision, zoning plan review.
Hi,
Hello, if you could state your name and address,
yes.
then I'll swear you in.
Maria Tavarozzi, 3 Apple Orchard Lane, Smithfield. Maria Tavarozzi, J-E-A-R-O-Z-I, 3 Apple Orchard Lane. I do, yes. Do you want them to state their names as well?
Well, are you gonna give us a little?
Yes, I can give,
And
yes.
and then if they would like to add, then I'll.
Yes,
we'll
so this is my grandfather Lawrence Coluca. He is the primary owner of 18 to 20 Esmond Street, and it is right now one piece of property with 2 houses on it. So we're looking to do a minor subdivision and split it into 2.
Could you try to use the mic?
Oh, yeah, sorry.
Could you
Okay,
close that door too?
Yeah. Thank you very much.
okay. So 18 to 20 Esmond Street is one piece of property with 2 houses on it right now, one single family and one two-family. My sister does live in one of them right now, and the other one is rented out, 2 units. So we are currently looking to split the property in half and have it as 2 separate properties. So she can own one and I can own one separately. And yeah, so we're looking to do a minor subdivision there.
Questions of the witness?
There is a mistake in the statement from State Line Surveyors. So I think there was the 20,000 square footage that's needed for each lot. The 20 Esmond Street, I think it's parcel A, is a single family, so that 20,000, that meets the required square footage. And then 18 Esmond Street, which is B, that is a duplex, so that's 2 family. I think that needs 40,000. So in the paperwork and the statement, it says 1,009 square footage of relief needed, and it actually is 21,009 feet of square footage. But if I'm not mistaken, all the properties around that area are pretty small compared to this property already. So it seems like a lot of relief that would need to be granted for that property, but it's so much bigger compared to all of the other units around.
Any questions of the board based on those last comments of the witness? Anyone else like to state anything in terms of the application?
No?
I want to give my 2 granddaughters them houses.
Yeah. Can you state your name, sir, and your address?
Please? My
Your name and your address, sir.
Lawrence Coluca, 134 Ridge Road.
You swear to tell the truth, the whole truth, nothing but the truth?
Yes, sir.
In your comment again?
Your comment, again. What did you want to say?
You want to give the
I want to
property
give
to
the
your
property to
grandchildren?
them, yes,
Okay.
before I go.
Okay, we're going to open the matter up for a public hearing at 8:05. If any member of the public would like to come forward and have comment, please come forward. Not hearing anyone respond, we'll close the public hearing at 8:06. Any discussion within the board of the application? Okay, we got a motion?
I'd like to recommend it.
Okay, and you want to put forth the motion
Yeah, I'm sorry. Yeah, I put forth the motion.
with the relief?
With the reading, yeah.
Do we have a second?
Second.
Okay, and just so we're clear, the relief,
Yeah, it's more than just square footage. It's frontage for both properties, 54, 70.26 feet of relief needed for both. side yard on 18 Esmond Street, which is B, parcel B, I think, was 1. Oh, it's A, 18? I'm sorry. And then the angles, we tried to split it as evenly as possible, so each one of us has the same square footage, and there's also access to Oak Street in the back. So again, we tried to make it so both properties have access to and from Esmond Street and Oak Street, so that's why those lines are drawn the way they're drawn.
Charles, go ahead and amend the motion a little bit.
Yeah, for the relief requested, the frontage is 70 feet and 26 inches. The side is, what was that, 1 foot 8 inches? Right?
1.8.
1.8. So we grant it. At a 30 degree, at the
31 degrees for the
31
angle.
degrees angle.
And for the other lot?
It's 70.26 and 40 degree angle.
Second.
All in favor?
Aye.
Ayes have it.
Thank you.
That was my first one, Larry.
Yeah.
That's it? Thank you.
Next matter, 245 Reservoir Road, ID 2411, public hearing, minor subdivision, preliminary plan review.
Favor. Good evening, Mr. Chairman, members of the board. Just for the record, my name's Joe Casali, registered professional engineer. Office is at 300 Post Road in Warwick. With me is Mr. Gordon Ondas. So Gordon is the owner of the subject parcel. He can be here to answer questions as well. If I may, Mr. Chairman, quick PowerPoint presentation just to go over this application. I know that you've seen this before. We were here not long ago on a pre-application meeting. If I may, so 245 Reservoir Road, specifically Assessors Plat 48, Lot 30. Let's look where we are in the community. That's the most northeastern corner with Smithfield, North Smithfield, and Lincoln come together. You can see it's bifurcated by 295, 146, 116. Reservoir Road, and that's the subject piece. It's tucked in between Reservoir Road, 295, and the Lincoln Smithfield Town Line. Large piece, almost 600,000 square feet, just shy of 14 acres. Recently changed into the R200 zone. It should be known as well as the applicant also owns a budding piece in Lincoln, specifically that small triangle that we're going to incorporate into the areas of some of the lots tonight, and this other piece that we're also going to be taking a portion of. So when we look at the lots, you can see that the only wetland is points north, which is the Woonsocket Reservoir, actually Reservoir number 3. That's the jurisdictional 200-foot buffer area, which we'll be staying well away from. Again, in 2021, this lot was changed from the R80 to the R200 zone because of the proximity of it to the reservoir. In terms of the subdivision concept, the applicant is proposing roadfront lots, so no public infrastructure. All of the lots will be accessed off of Reservoir Road. He is looking to combine some of that lot 16 within sublot 1 to make it larger, almost 4 acres, and also a portion of lot 18 to make that sublot 2 a little bigger. So even though these portions of the lots will be in Lincoln, this will still be a Smithfield subdivision. Individual wells, individual septic systems proposed for the lots. Soil evaluations we took were about 2 feet, allowing conventional septic systems to be designed. And in terms of the proximity to the reservoir, we're not going to stipulate to conventional septic systems. We'll be putting something like a bottomless sand filter there. That'll have advanced treatment that will help for the phosphorus, which is what the concern is in terms of the reservoir. As you know, phosphorus occurs in a lot of the lawn fertilizer and so forth and so on. as well as the drain field for the septic system being bottomless sand filter. Again, with the sand, the tertiary treatment will help with the pathogens, the nitrogens, and the phosphorus. Same with the stormwater, we'll be choosing specific BMPs such as infiltration trenches and sand filters so they can filter out any type of phosphorus that we have in the area. In terms of relief, being in our 200 zone, we need relief on all 5 of the lot areas and 4 out of the 5 lot frontages. You can see that the lots are anywhere from 76,000 square feet upwards of 100,000 square feet. Relief requested anywhere from 45,000 upwards of 123,000. Same with the lot width and frontage. In this community, as you know, Mr. Chairman, bless you, has both the required 300 feet of width in frontage, and you see what we have, which is shy on all of the lots except for Lot 2 in the respective numerical relief. We're requesting anywhere from 35 feet all the way to 114. In terms of permitting, this application is relatively simple because it's road front lots. Pre-application back late last year. Tonight is actually a preliminary plan in front of the unified development, no more master plan for these small lots. And if you see to approve this tonight, we request the final plan via administrative officer. As I stated, Mr. Chairman, the owner is here with me tonight if there are questions of us.
We'll begin with questions from the left at this time.
Sure.
This is an R200 zone. Shouldn't you be asking for 4 lots?
4 lots by right, Mike, yes. But when you look at the surrounding area, specifically right here, you can see in the aerial to the south, you've got non-conforming uses. You've got industrial uses that are actively here working. You have similar neighborhoods, which you have the similar frontage right in the nearby neighborhood. We think this is a reasonable ask. This was an R80 zone, which all of these would have been allowed by right. I didn't want to play games and create frontage with cul-de-sacs and roadways. We think this is a clean, simple applications for 5 single-family homes, and we hope you consider it.
No question. Charlie?
Yeah, originally, I thought the 4 was what we should have done. By looking at it now, I drove up there, it does kind of blend in, and I'm willing to let it go. I think it's, I can see why you'd have to make a cul-de-sac and be, let's put it this way, it's better than condos.
Well, it is. It's a simple, straightforward road front. When's the last time we've seen a road, right? A road front subdivision? They're few and far between.
That's what this town used to be like, that's what we should go back to.
Charlie, not that we can discuss that now, but we need the vehicles to do it, right? You look at this lot, there's this vehicle of 4 lots by right, and then there's 42 lots by right in terms of condominiums. There's no in between.
No, I changed my mind. I looked at it.
Thank you.
Okay. Questions going around?
Yeah. So, Joe, the water table.
Yeah.
On page 4, it says, water tables at 15 or 24 inches below the surface. And then it points you to Exhibit A, Appendix A. Can you just educate me on where a potential buyer would understand what they're buying? And I understand the septic system, but my concern is foundations. It's building within the water table of 18 to 24 feet. I mean, what, costly to put in any type of basement, probably, and footings and foundation walls and stuff like that. So you point to it, my concern is that, future buyers may or may not understand what they're buying.
Yeah, no, it's a fair question. So twofold. One, on the septic systems, DEM will allow septic systems conventionally on 24 inches. They'll mandate an innovative alternative system like a bottomless sand filter at 18. So while we can put conventional systems here in consideration of any approvals, we will stipulate to the highest and best treatment, such as bottomless sand filters. So you're looking at a Vantech system. It will reduce the nitrogen by its design. We can put UV lights in them to reduce the phosphorus, and then we can further treat them with the sand filter for the phosphorus as well. And if it makes the board comfortable, we can deed restrict that so buyers know that they're buying a site with an innovative alternative system. It's not a $25,000 system anymore. It's a $40,000 to $45,000 system. And the same thing for the foundation. I know you know as well as I do, I live on a lot with a 12-inch water table. It's going to cost money to either put foundation drains, which DEM may not like because of its proximity to the septic systems, or they're going to have to seal and watertight these foundations. I don't think it's astronomical in terms of cost. I think it's doable from an engineering standpoint. But you're right, these, when you look at these sites, I think you got to discount them a little bit in terms of the price because of what you're going to pay, another $15,000, $20,000 on septic systems and probably another $5,000 on your foundation. I think the only way to protect the end owner is to deed restrict them. So when they are looking at this, doing some type of title search, that restriction will come up and an owner will be aware, okay, I'm not only going to pay more for my system, I'm going to see it and perpetually pay for it electricity-wise.
Thank you. Do we see any issue putting a deed restriction like that on these properties?
No, especially if they go into stipulate.
Any other questions? Any other testimony before I open it up for public hearing? Okay, it's now 8:19. We'll open the matter for public comment. Anyone who'd like to be heard on the matter, please come forward. If you could state your name, sir, your address, then I'll swear you in.
Yep, James O'Brien, 44 Orchard Meadows Drive in Smithfield.
Okay, you swear to tell the truth, the whole truth, nothing but the truth?
I do. Was this parcel of land, I see it's for 5 single-family residences, whatever under consideration at all for a large condominium development or apartment complex?
Mr. Casale, do you have any knowledge of that?
We presented the yield when we saw you.
But not as a, that wasn't your plan?
Not to my knowledge, other than.
Showing what you could do?
We know what it can yield, but not to my knowledge. I don't know of any layouts that are out there right now.
Okay, and so going forward, this will be considered and ultimately deliberated on and voted on based on single-family dwellings and 5 lots?
That's correct.
And there will be no alteration or change in that plan?
And not in terms of the use.
Okay.
That's what I was worried about. That's why I decided to let it go rather versus letting it be developed into more. But this is a better plan. It fits in better in that property than their rights of having another fit about 200 condos going in. I agree with you, sir.
Okay, thank you.
Anyone else from the public that'd like to be heard? With no one responding, we will close the public hearing at 8:21. Discussion, board members? Okay. Anyone with a motion?
Mr. Chairman, Again, I will move to approve this, granting relief as follows. On lot number 1, relief of 123,050 square feet and a frontage relief of 135.81. On sub-lot 2, relief on the area of 75,006 feet and no mention of frontage on that lot. On sub-lot number 3, 45,803 square feet relief and 71.6 feet relief on frontage. On lot number 4, relief of 57,106 feet for area and 57.69 feet for frontage. And on lot number 5, 690 square feet with 19.8 feet on frontage. In addition to that, I believe that the developer or the person who owns that property will stipulate to certain items to be included in the record.
Yes, innovative alternative septic systems and phosphorus reduction drainage.
And that be part of the motion.
Is that, we're going to include a deed restriction that,
In a deed
we
restriction.
can discuss it if you want.
No, I think that's appropriate. You want to include the deed restriction as well?
Sure. Including the deed restriction as proposed by the developer
During the testimony.
during his testimony.
Excuse me, Mr. Chairman?
You also conditioned on the deed restriction.
That's correct.
That you agreed to during, or intimated an agreement to.
Correct.
During the testimony. Okay. Do we have a second? Mr. Boyd. All in favor?
Aye.
All not in favor? Okay. The ayes have it.
Thank you.
Finally, we have general public comment. If anyone has public comment they would like to be heard on, please come forward.
I can be the first.
If you could state your name and your address.
My name is Nancy Lancaster, and I reside at 22 Lori Ellen Drive, Smithfield.
Public comment? Is ready to go?
No swearing on my part, huh? Okay. These materials I have are being given to the board to provide adequate time for you to review regarding the condo development on Lime Rock Road. It hasn't come before you yet. What I have for you is a partial listing, but it's greater than 200 names with 100 more that I just ran out of time typing in. Should the board need all of them prior to the time that this comes up for review, I can deliver them at a date that you determine. Please review the overwhelming response from the associated neighborhoods of their non-support of this condo development. It is our hope that strong consideration of the interests of these Smithfield residents be included in your discussion prior to the time that it comes up for public.
Thank you.
Okay? May I ask that these be included in the record?
We can't, this is just public comment.
Okay.
You're more than welcome to present them to the town planner, and the town planner will, as appropriate, when the application comes before us, get the information before us. That would be the proper method.
Okay, very good.
Thank you.
Thank you.
Anyone else from the public that would have any comment today? You probably know the drill by now. If you could state your name and address.
Hi, my name's Luigi Solda. I live at 3 Laurie Ellen Drive in Smithfield.
Swear to tell the truth, the whole truth, nothing but the truth.
Of course. I'm also here to talk about the collection at Lime Rock Acres condo development. I know your job is to plan and zone, but I want to really point out the effects that this will have on our town. They're proposing 218 four-bedroom units. At your December 12th, 2024 planning meeting, it was stated that the town would receive $2 million in additional revenue from this project the first year and $1.5 million per year thereafter. The developer has emphasized the revenue to Smithfield, but I would like to emphasize the cost to Smithfield. It currently costs $18,500 to educate a child in Smithfield. If only half of the condo units have 2 children in our public schools, 218 students times $18,500 is $4,033,000 a year. This equals a $2 million deficit to the town the first year, $2.5 million deficit per year thereafter. Over the 13 years that a student is in our public school system, the revenue from this development would be $20 million, but the cost to our taxpayers would be roughly $52.5 million, a deficit of $32 million over the 13 years, assuming that the cost of education remains the same. If 3/4 of the residents have 2 children in school, then 327 students times $18,500 equals $6,049,500. This equals an over $4 million deficit the first year and $4.5 million deficit for every year thereafter. Over 13 years of public education, the revenue from this development would still be $20 million, but the cost to taxpayers would be roughly $78,643,000, a hefty $58,643,000 deficit. How will the town make up for these deficits? They will raise taxes. They'll raise my taxes, they'll raise all of your taxes. Everyone in this room and everyone across the entire town, not just the residents of Lime Rock. This isn't just something for those of us that live in that area. This is a concern for everyone in our community. A deficit of between $32 to $58 million at a minimum will be on the shoulders of every taxpayer in Smithfield. I urge this planning board to strongly reject this proposal. That building has no business being in our town. It will cost us dearly. Thank you.
Thank you. Anyone else in the public that would like to be heard tonight? With no one else responding, the public hearing is now closed at 8:31. We have a motion.
Mr. Chairman, I move that we adjourn the meeting of the planning board this evening.
We have a second.
Second.
All in favor? Aye. The ayes have it.